I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. Today on Rochelle's Daily Wire Video Edition, I am featuring a provocative decision that I cover in my column today on ABI's website, written by Bankruptcy Judge Sage Sigler from Atlanta, Georgia. The decision is provocative because it touches on the one single hottest topic today in bankruptcy, and it's this: do bankruptcy courts have the power to issue non-debtor releases to third parties under Chapter 11 plans? That is the very issue that will be argued in the U.S. Supreme Court in a case called Purdue Pharma on the 4th of December. Judge Sigler, in a case that's really quite different from Purdue, found the power and the authority to issue these non-debtor third-party releases. Her case was really quite different from Purdue. First off, there were no unknown creditors. All of the creditors were known, and all of the creditors received notice of the bankruptcy case, an opportunity to vote on the plan, and an opportunity to object to the plan. And yet, all of the voting creditors voted in favor of the plan, including those who would be bound by these non-debtor third-party releases. As I said, there were no unknown creditors and no future creditors. However, some of the creditors who would be enjoined by these releases simply did not vote on the plan. They stayed silent. However, they did not object to the plan. Now let's go for a minute to the Purdue Pharma case. Most folks I'm talking to these days are guessing that the Supreme Court is going to reverse the Second Circuit and say that at least in the circumstances of Purdue, there is no statutory authority to issue these non-debtor releases. However, as I said, Judge Sigler's case is really quite different. And what I am worried, if not concerned about, is whether the Supreme Court, when it decides Purdue, is going to make a flat-footed, broadly worded prohibition on third-party releases. Or I'm wondering, will the Supreme Court simply say, under the extraordinary facts of Purdue, are those releases impermissible, but perhaps permissible in cases more like Judge Sigler's, where it is either completely consensual or very close to being consensual. As I said, I am Bill Rochelle, editor-at-large for American Bankruptcy Institute. I shall return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and a good day.